Welcome, everybody. Welcome to our weekly Cyber Policy Center lunch. We are thrilled to have, as our speaker today, Florence G'sell. Florence holds the Digital Governance Chair at Sciences Po and teaches at University of Lausanne. But most importantly, she is the inaugural director of our program on governance of emerging technologies here in the Cyber Policy Center. I also want to just acknowledge that we're thrilled that from the Project Liberty McCourt universe, we have Tamika and Alex, who are leading that effort, and this program on governance of emerging technologies is really a result of the initiative that is a multi-university initiative looking at all of these different issues that we cover here in the Cyber Policy Center. And this talk that Florence is going to give is a window into a giant report that is coming out of the CPC and of the Program on Governance of Emerging Technologies on regulation of generative AI. And this is one of 3 reports that we'll have in the next few months, one on generative AI, one on virtual and augmented reality, and one on blockchain. And this is sort of looking at it from, looking at policy proposals in all 3 of those domains. I will add that this has become I want to say it's been a labor of love for you, but I shouldn't put those words in your, it's certainly been a labor, because in writing a giant report on governance of generative AI, one of the biggest challenges is knowing when you're done. Because things are changing every week in the governance of generative AI, and so this has turned into a beast of a report. So those of you in Silicon Valley and beyond who are joining us by Zoom, please email me, Nate Persily at stanford.edu, if you're willing to offer some comments on this report, because it's the more feedback we get, the better. And so, as with all of our sessions, she'll talk for about half an hour. We'll have questions from the floor. Those of you who are on Zoom can submit your questions in the Q&A function. And I will turn it over to Florence G'sell.
Thank you so much. So I'm very honored to be given the opportunity to present a few thoughts about this very difficult question of the regulation of generative AI. Shall I use the mic? I'm good? OK. As Professor Persily said, it's a very long report that we are currently drafting. When we started working on that question, it was in the summer. And at the time, we had the Parliament's version of the AI Act. And since then, we have seen the various updates of this important regulation with many changes, many debates, many disagreements. And now the AI Act is on the finish line. It will be adopted in a few weeks, as I will explain. So hopefully we're done. But of course, I'm talking as a European scholar that is obsessed with what's going on in Brussels. Of course, we're not done with the rest, and we're not done with everything. So what are we going to discuss today to deal with? What is this report about generative AI models? I will not spend too much time on this. Of course, this has been extensively discussed and debated. And we have, today we are accustomed to use those tools, to use ChatGPT, for example. What is important is to highlight the fact that those chatbots that we interact with on a daily basis, for some of us at least, are based on more general models, broader models that we could call foundation models. You have various expressions that are used to designate those models, basically. And you can see that this definition that is the most widely adopted definition is a little vague, but basically you have a few criteria to determine what a foundation model is, the volumes of data that are immense, the fact that those models can be fine-tuned to achieve various specific tasks, the fact that they are complex, and that they might have unforeseeable capabilities. And this is what's at stake at present, and this is the reason why I call that presentation Regulating Under Uncertainty, because there are so many things that we don't know. How they work, what they can do, what they could do in the future, what users could do with them. I wanted to give a positive example of those enforcing capabilities that was released last December. The official publication is dated from January, but basically in December, it was announced that an LLM was capable to solve a mathematical problem that had never been solved. And what is interesting is that when this study was released, it was said, well, nothing was in the training data that could help solve that mathematical problem. It wasn't known. It was a problem that no one had solved, and the LLM could solve it. So it's fascinating. It's probably one of the first examples of this kind, but of course we will have other ones. And of course, we can feel a little bit worried about what is coming, because we are talking on a daily basis of all those possible risks or those established risks. We know that those models can hallucinate, they can produce inaccurate information, inaccurate content. There is this problem of discrimination that has been highlighted about machine learning tools for quite some time now. You have many other concerns, and I would like to quote here something that was said by Sam Altman a few weeks ago in Dubai, because I liked the expression that he used, very subtle societal misalignments. So basically what he says is that he's not that concerned by killer robots. He's concerned about those things that can go horribly wrong, even if at first you do not notice them. And so this is what he calls misalignments. And of course, when you're a regulator, when you need to make decisions about what you should do, about the technology that is emerging under uncertainty, you need to keep this in mind. But what should your behavior or your decision be? The first possibility would be to say, well, as a policymaker, as a regulator, I don't do anything. This is emerging. We don't know. We don't even fully understand the technology. We do not know the future, and we want to help the industry grow. We want to promote innovation. So as a regulator, as a policymaker, I could just say, well, let's let the industry self-regulate. The industry knows, experts know. So we could probably trust those companies to establish industry standards, best practices. They know about safety. They can develop safety standards, develop a risk governance, and of course, this is adapted to the pace of AI development. As Professor Persily says, the landscape is evolving at a very rapid pace. So it's convincing, but it's probably not sufficient. How can you trust companies that basically want to make profit, that are tempted to release models that are not sufficiently tested because they want to make profit? So the other possibility would be to say, okay, as a regulator, as a government, I'm not drafting a framework for now. It's too early. So I try to adopt an approach that we could call light touch. So as a policymaker, I encourage the industry to self-regulate, and I try to use what I already have, the existing framework, for example, anything that I could use, for example, data protection framework or competition law to mandate compliance with basic standards. So this is how probably I could call, or what I could say about the US approach. I will not spend too much time on this. I'm in front of an American audience. As a European scholar, I would just say that here in the US, NIST has released standards starting in January. These standards on AI are currently being updated to be adapted to generative AI and foundation models. And of course, it's important, even though those standards are not legally binding, strictly legally binding. Another option that I find very interesting, because this is also what the EU Commission is currently starting to do, even though it is also adopting mandatory frameworks, but trying to get from the major companies commitments that they will, for example, test their products before release, that they will be transparent about their models, and so only, for example, release their model weights after looking at the possible risks, ensuring that those companies use techniques to make users aware that they are using synthetic content. So this is called watermarking. And so this is something that we could discuss because this is also imposed in the AI Act, and I think it will probably create enforcement issues. You have existing authorities that are currently investigating on generative AI companies like OpenAI. It's the case of the FTC. And of course, as you already know, there was an executive order that was adopted here in the US a few months ago that basically mandates that the main risks be assessed. So it's mostly provisions that provides that some reports should be drafted. So it's not really binding, except for a few provisions regarding the most powerful generative AI models and regarding the compute infrastructure. So the Department of Commerce is going to implement reporting requirements for developers of dual-use foundation models, at least the most powerful one, and also requirements for large-scale computing clusters. So those operators will have to disclose information to regulators. It's not that much, but it's interesting to see, for example, that red teaming is part of the kind of information that must be released by those developers. One remark here, the executive order starts with many definitions, very technical definitions, and for a European scholar like me, it's very important and very interesting because you do not find as many precise definitions in the current version of the AI Act, which is something that is worth highlighting, and so we are currently in that report trying to make a comparison between the various definitions that we find in those different regulations. So the last possibility, the last option that you have as a policymaker is to regulate. Just to say, well, okay, I'm in the middle of an uncertainty, but I want to take action. I want to do something because the risks are too high, and we cannot afford as a society to let those technologies grow, develop without safeguards. So of course you have disadvantages of this approach because it's very challenging to design a targeted framework, something that is really adapted to the current state of the technology. And so this is what we probably can see with the experience of the drafting of the AI Act. There is a risk of regulatory capture. Why? Because if you're let's say the EU Commission, if you're a regulator, a government, you need the technical expertise. And where is it, the technical expertise? Mostly in the industry. So it's very difficult for a regulator to draft a regulation that is adapted. And of course, and this is what we are witnessing in the EU at the moment, it's also a problem regarding enforcement. When you need to enforce it, you also need those experts, you also need the industry, and there is also a risk of a regulatory capture. So you have problems related to this option to regulate, but you have also many advantages because, of course, self-regulation is not sufficient. You need to establish mandatory standards, and you need to have authorities that are competent to take enforcement measures and to supervise what AI companies are doing. So this is why the EU AI Act was adopted, and I want to insist on the reason why it's so important. Basically, and as far as I understand it, this act is regulating the world, and the industry is will adjust to these standards. Why? Because the act regulates providers, whether they are established in the EU or in third country. Also deployers, that are people that use an AI model or system under their authority when they are established in the EU. But there is a third point. The Act covers any provider or deployer that is established outside of the EU if the output of the AI system is utilized in the EU. Utilized. So my interpretation would be to say, well, so as soon as the output is accessible from the EU, then it is within the scope, because how can you check what people do with the output that they access to? So I would say, well, okay, so as soon as there is something that is accessible from the EU, it's within the scope of the Act, and so this explains why most companies are currently trying to preparing compliance with the Act. So it's and the pace is very, very rapid, because as far as I know, the final vote on the AI Act will take place in a few days, on March 13th. It will be the final vote in Parliament. The Act will probably be published in April, and then it will enter into force 20 days after its publication. So if you look here at this timeline, you'll see that 6 months, well, I would say in October, all the banned AI systems under the AI Act will be effectively prohibited in the EU. We will come back to this timeline later, but it's interesting to see that it's coming very fast. Especially for general purpose AI models, because in 1 year, all the provisions will be enforceable. So there was a problem when the AI Act was drafted, because the first version of the AI Act, the first proposal of AI Act from 2021, focused on use cases and said the technology itself is not that risky, that dangerous. What can be dangerous is what you do with the technology. So we select the riskiest cases and we regulate them. But then ChatGPT was released. You had this very intense debate about it. And this is why during the course of negotiation, it was said, well, we should regulate some aspect of the technology, some aspects of AI, namely foundation models, and this is what you could see in the Parliament's version of the AI Act that was voted before summer. But of course, when you want to regulate the technology itself and not its use cases, you need to define it. And it's very difficult, actually, to define it. What I would like to insist on is how there was this evolution from a risk-based approach centered on use cases to another approach that is less clear because that it integrates provisions related to the technology, to the models themselves. This pyramid is basically how the EU Commission has presented the AI Act since the beginning. So you can see that it's really risk-based and based on use cases. You have some use cases that are considered unacceptable. You have use cases that are considered high risk. You have use cases that are considered limited risk. So let's say a few words about all those categories. Some applications are totally fully banned in the EU. Let me give you one example, the example of social scoring that is banned. It's also the case of crime prediction tools that you use here in the US that have generated much debate. They are basically prohibited. Then you have those use cases that are considered high risk. Why? Well, because they are related to certain type of services, of sectors, of applications. So, for example, medical devices, toys that are already regulated under EU law, but also other type of sensitive areas like AI models used in education, in the judicial system, in democratic processes. And if so, then you have very, very stringent obligations that should be followed by providers. So again, this is how the AI Act looked like in 2021. Third category, remember the pyramids, what you could call limited risk, but I don't know if it's really that limited. But you have a list of applications where disclosure is mandatory. For example, disclosure is mandatory when you have a chatbot that interacts with people. People must be aware that they're interacting with a chatbot. People must be aware that they are facing or reading synthetic content. So watermarking is mandatory. People must be warned that they are looking at a deepfake. They must be aware that, for example, a media, a newspaper used AI-generated content. So you have all those cases where the use of AI must be disclosed. So to conclude on this, I would say, well, it's not that. This is the diagrams that we have tried to draft here at the CPC. And of course, I would take any comment on this and any critique. But I would say, well, it's not that a pyramid because you have overlap, especially between the high-risk category and the limited risk category. You can have a chatbot that is high risk. If this chatbot is used in a higher education institution or in the judicial system. So you have overlap, and this is the reason why I do not trust these pyramids that much. But what happened during the course of negotiation is this. You have another layer that was added to the existing framework. And this new layer is about generative purpose AI models. So what did the drafters of the AI Act decide to do? They decide to regulate specifically general-purpose AI systems and general-purpose AI systems with systemic risks, which are defined as models that have high impact capabilities. It's interesting because there was discussion about the definition of those models that raise a systemic risk, a very important risk in the EU. And the criterion that was adopted is the criterion of the computational resources used to train the model, which is, I think, controversial because you can have a model that is trained with a small amount of resources, of computational resources, then can be very risky. But this is the main criterion for now. But of course, this will evolve over time. This can be revised. This can be modified. And of course, the Commission is empowered to designate those general purpose AI models that raise a systemic risk. So what happens in the case where a general purpose AI model or foundation model is designated, and if this foundation model is considered as with systemic risk? Various stringent obligations apply, which are basically transparency obligations, when you can see that they must provide the technical documentation with information about their model. They must inform their downstream providers. This is common sense. And you could say, well, this is what the industry is already doing to a certain extent. So what is game-changing in this list? First, there is a provision about energy consumption. It's interesting to see that those companies should disclose the energy consumption used to train their models. To train them, not to use them or operate them. So I would say it's not enough. But anyway, at least it's a first attempt. What is also game-changing here? Well, you can see that it is required that they provide information about the content used for training, which is really new, and we'll see how this is enforced. And they will have to implement a policy to comply with copyright provisions. It's a complicated issue. I know it's also a heated debate here in the US with various ongoing cases. But you have new obligations that I think are of interest. Of course, the industry and some companies have been complaining about the fact that it's very stringent, that you will have huge compliance costs. But I would say, still, it's common sense. You need transparency. You need more information about what these companies are doing. And you want to know what content they use, what content they web scrape online. One remark after I stop, maybe two quick remarks before I stop. The ambiguity with open source. And so we are not finished with this debate about open source. Why? Because the AI Act starts by saying this act is not covering open source. And then you have all those exceptions, except if it's a prohibited AI system, except if it's a high-risk AI system, except if it's an AI system requiring disclosure, transparency, watermarking, etc., except if it's a general-purpose AI system. So basically, I would say, well, the AI Act is covering open source. What is interesting is that there is a small exemption of transparency obligations for what is called free and open source models. But the definition of open source here is quite narrow because you have to be considered open source under this framework. You need to disclose everything, weights, architecture, use cases, etc. So I would say, well, is there really an open source exemption? I would doubt that. So just one last point about the AI Act, and I will stop about this. It's the fact that the Act will be implemented at national level. It's for member states to designate the authorities that are empowered to enforce this Act, except in one case where the AI office that is part of the EU Commission is competent and acts as a market authority, except in the case where you have a provider that provides a general purpose model and an AI system based on that general purpose model, with basically OpenAI with ChatGPT and GPT-4. And in that case, it's the EU Commission that is directly competent, the AI office within the EU Commission, which is an important aspect. Maybe one last remark, because as I said, in a few weeks, the AI Act will be adopted, but at the very same time, there will be another important legal framework that will be adopted in the EU, which is the Product Liability Directive, that is designed to cover the liability about softwares, when a software is defective. And this is very important. Why? Because a software can be considered as defective when it doesn't provide the safety that a person is entitled to expect. So the public at large. So what is the safety that you expect from, let's say, ChatGPT, or any type DALL-E, or any type of generative AI model? So this is a debate that is not finished. And so it's only the beginning of it. Of course, it's a directive. The scope is really the EU. So there is no extraterritorial effect of this text, but it exists and it will be implemented, and it's worth mentioning it. So I will stop now. I've already been too long.
Well, thank you so much, Florence. I want to start with a bit of praise for you and us in doing this project, which is to say, we couldn't have done this work without you, but also how important it is in academic institutions that we have people who can explain the complexity of these legal regimes. It's actually quite rare, I think, where there aren't the rewards for academics to publish explainers like this, and yet it is so important that we understand this. And so I'm going to ask a few questions, principally in your role as I'm going to say European ambassador to the Cyber Policy Center, although I don't want you to traipse on Maricha Shake's land as well. So since we have definitely several European perspectives here. So let me just start at kind of 10,000 miles above, which is in thinking about what happened in the EU and comparing it to other kinds of regulation of technology that the EU has done. GDPR, as well as in particular DSA, and thinking about like, what are the different ways? I mean, as you know, and we've had several speakers come through here talking about the Brussels effect, talking about how, America innovates, Europe regulates. Is the AI Act following a similar path to the other sort of European regulations of technology, or do we see something a little bit different here? And underlying my question is also of the fact that actually there are European AI companies in ways that there weren't, say, European social media companies, right? And there are efforts like with Mistral and these others. And so could you give a sort of just window as to how this regulatory effort compares to, say, others that the Europeans have engaged in with respect to technology?
Okay, so let's take the example of the GDPR. It's a good example. The GDPR, I wouldn't say that it was something that originally was designed to, let's say, regulate the world or to have effects beyond the EU borders. Why? Because the GDPR basically was adopted after an important directive that was adopted in 1995, the Data Protection Directive. So at some point, it was felt that an update was needed, and of course there is an international effect, especially since the GDPR regulates data transfers. So I don't think it was originally the intention to have effect outside of the EU borders, but it was, and it was studied, it was factually established. As for the rest, my impression about those regulations that were adopted about the past 4 or 5 years, such as the DSA, for example, is basically that the feeling in the EU is that we intervened too late. And it's very true when you look at the DSA that was adopted years after social media were developed and strongly developed in Europe, widely developed in Europe. So I think this is what's currently taking place with the AI Act. We do not want to intervene too late, because we were too late for example, social media. And here, we want to be the ones that provides the standards, and that provides the standards that will be internationally followed. And I would say that, sorry about that, but there is this idea that, well, if the Americans are not doing it, we're doing it. And so, yes, so here, in this case, I think the intention is really to set the international standards.
Can you talk a little bit about the politics of this inside the EU? And so one of the interesting phenomena I think we saw as they started talking about general purpose AI models was that maybe there were some differences between the member states as to how to think about this between the Germans, the Italians, the French, and the rest. I'm not so sure people are familiar with that. Maybe talk a little bit of the politics of regulating AI in Europe.
Yes, well, I will start with...
Let me just interrupt. Those of you online, we're starting to get some questions over the transom. Just put them in the Q&A in the Zoom. Yeah.
So yes, I would answer that by saying that you have two main preoccupations at the EU level, but everywhere. First, of course, regulating and making sure that you have safeguards in place. But second, promoting innovation and promoting European companies. And of course, this is what we witnessed during the negotiations on the AI Act with, in December, at a very late stage, we saw three countries, namely France, Germany, and Italy, saying, well, we do not want any provisions on foundation models. We do not want any binding framework on foundation models. What we advocate for is what they called mandatory self-regulation. So we trust self-regulation, but we want to make it mandatory. And I heard a couple of times here that mandatory self-regulation doesn't mean anything. So I asked about it. I asked a question to my European colleagues who told me, but it's an American concept. And so I'm happy to have this discussion with anyone here to, just to determine what mandatory self-regulation is. But yes, so we had this...
By the way, my parenting philosophy is mandatory self-regulation. That's sort of the way I think of it. Yeah. Keep going. Yeah.
So you had, and why did these three countries adopt such a stance? Clearly because they wanted to protect their own companies, and it's particularly true with France and Germany, because they all have their champions. And so this is what was said in France. We want to promote a European version of generative AI or foundation models. And of course, we promote transparency, we promote open source. So yes, there is this preoccupation, which is not strictly speaking protectionism, but it's still a little bit paradoxical.
I want to talk about the open source issue, but I also want people, since we have a huge crowd here and also online, a kind of record audience, if anyone has questions, please raise your hand and then we'll start passing the mics around. So talk a little bit about open source, and you ended with that, and we here at Stanford are not using the word open source anymore. We're saying open models or models with open weights, right? That's what, and we all recognize that openness is a spectrum. It's not an on-off toggle. Just to say the party line here a little bit. How should we think about the potential, really, of any regulatory body, but in the EU, how they're going to regulate open models going forward? Because it seems like a kind of, I don't want to say an impossible problem, but it seems like a very tricky regulatory challenge.
So it's very challenging. My first remark about this is to say that when you look at those European frameworks, it's not just open source, it's free and open source. So this is the idea. You might have an exemption for those systems, those models that are not just open and transparent to a certain extent, but also free of charge. And if you monetize them one way or the other, you're not considered as open source. And it's interesting to have those two ideas used at the same time and used together, because it's not that obvious that they go together. Of course, you have a way to monetize open source models. You have various strategies by offering other services, for example. And so this is what I'm wondering about, how open source is dealt with in those frameworks. Because as far as I know, a real free and open source model under those definitions, it's rare, or it's so. But then, if you have a few of them that are like this, so basically models that would be available on the internet, that would be fully open, that you could modify, that you could use, then it's very difficult to follow what users can do with them. And they can use them to do horrible things. And it's probably what Sam Altman is worried about.
Well, it will be interesting, given that we've got a French open source model that is out there, right? That when, you know, that could be the first test of this, you know, depending on how people might end up using it. I think we've got a question over here. Oh, I'm sorry, someone on the ground there. Yeah, is that Kevin? Yeah.
Hi, thanks so much. I was curious your take on the transition from the Parliament's version of the AI Act to the final version. So just on transparency, some of the transparency requirements in the Parliament's version were gutted from the final version, and there's now nothing on copyrighted data, personal information and data, carbon emissions or water usage of the data centers, rigorous evaluations of limitations, risks, or mitigations, or anything about the downstream usage.
You have, of course, so the Parliament's version was more comprehensive and stringent than the final version, but you have still some provisions that are still in the text. About copyrights, it's pretty clear. So I didn't explain this in my presentation because understanding this, the status of web scraping under EU law is a little complicated. But you have really, I think, provisions that are clearly explaining how the protection of copyrights must be ensured. Those companies must adopt a policy to make sure and justify that they adopted a policy to ensure that copyrights are respected. You mentioned water consumption. So as I said, yes, they kept the provision about energy consumption, and it's not as stringent as it was in the Parliament version. As far as I remember, it's only the energy consumption used to train the model, and it is also said if it's not possible to give a very precise assessment, then it's okay. This is my understanding. So, of course, the Parliament's version was the one that that was the most stringent for AI companies, and since there was this pushback during the negotiations, of course, we have a lighter final version. Just one last remark about the training data, because we have interesting precisions in the final version. As I said, so there must be information on the training data given by the developers of general purpose AI models, but it was also said that this information doesn't need to be detailed. For example, you don't have to provide a list of the websites that you web scraped to gather data. So you can just mention, very broadly speaking, the databases that you used. So again, so it's not very precise, and so we might regret that. But it's the result of a compromise.
Hi, I'm Josh Glonek, a visiting scholar at CSAC. One of the limited risk factors that you talked about had to do with deepfakes, which seems like a particularly important one this year with a number of elections happening. But the regulatory requirements seem to be essentially attributing that the deepfake was produced using AI. But by definition, a deepfake is supposed to deceive people into thinking it's real content. So can you just explain more? Who are we regulating? Is it the technology company, or is it someone who's actually producing the deepfake? And how is that something that could be enforced?
So yes, so in those provisions, you have certain obligations that target providers and other obligations that target deployers, users. Deployers are users that use an AI model under their authorities. This is the definition. So in the case of deepfakes, you're a user, you're a so-called deployer, and so you are expected to let people know that the videos that they are watching was produced with generative AI, is purely synthetic. So this is your obligation as a deployer. You also have a watermarking obligation that is imposed on providers. And we'll see how it works. We'll see how it works. But the idea is that everyone that see or read an AI-generated content should be aware of it.
Let me turn to one of the Zoom questions that we've got, and this has to do with sort of non-European collaboration with the EU on regulating AI. And so Carlos Escapa asks, how do very large non-Western countries, apart from China, collaborate with the EU in AI regulation in India, Brazil, Indonesia, for instance? Any thoughts on that?
Thanks for this question. I know. Anyway, hello, Carlos. Thanks for this question. I know it's a preoccupation for you. So as far as I know, and I should certainly check that, I am not sure that the drafters of the AI Act have strongly or closely collaborated with representatives of third countries such as Brazil or China. So I think it's really a European project. I think, and this is what we are currently doing within the context of that report, we are trying to look into the frameworks that have been adopted in China, for instance, how different they are. They are not that different when you look at the principles that were adopted. What is of interest, and this is why I mentioned how definitions are important, is that every region or every country has its own definitions. And of course, definitions are critical. It's critical when to determine how you define a foundation model. In the executive order, it's dual use foundation models, and how you define red teaming or so.
Can you just talk on that first point? What, because I think that is a critical point that's made in the report. What is like the difference between the U.S. and EU definitions of the, of foundation models, but there's the general purpose AI systems, and then there's the dual use foundation models. I know this seems to get technical, but it seems pretty important as to what exactly is being regulated here.
So it's absolutely critical, and let me add one remark before I answer you. It's critical because if at some point we want to have a real international approach of the governance of those AI models, we need to agree on definitions. And so this is why we are currently doing this comparison between the various regulations, because I would say that the definitions that you can find in the executive order are technically more precise than the definitions that you can find in the AI Act. So the AI Act favored, so you had various expressions. In the Parliament's version, you have foundation models.
Coined here at Stanford, I should say. That phrase is something we made up. Yeah.
But finally, the expression that was, and I'm not totally convinced with this expression because it's very vague and the definition is very vague, but finally it was decided to use the expression of general purpose AI model. General purpose, why? My understanding is that just it's as opposed to the specific purpose AI models that are regulated in the original provisions of the regulation. So general purpose AI models, why not? Well, it's the idea that they can be fine-tuned, they can be adjusted to accomplish specific tasks. In the executive order, the White House provides more precise and technical definitions. So you have this idea of dual-use foundation models that is far more precise. For example, it is said that those models have tens of billions of parameters, for example. So it's far more precise. You have more technical definitions, and I think it's important. And I regret that the EU did not adopt more precise definitions and more definitions, because we need them. And so this could be, you could have more work on that question.
So Peter Lissy asks on Zoom, what do you think, consider the chances that the EU regulatory model will actually become the standard worldwide? Will this follow the pace of GDPR? You seem to suggest that because Europe is essentially out there already. And for that matter, it anticipates being the world standard, because as you say, if you're making it available to EU citizens, and it's hard to think about how that's not going to be the case. I mean, I suppose, Sam Altman at one point did say that, all right, look, there's a chance we just won't make GPT available in the EU. But even that it seems it's going to be hard to cabinet, because somehow the products of those AI models might be in Europe, right? So do you think this will follow the route of GDPR and really become like the standard as it was for privacy around the world? This will be the AI standard?
My impression is that it will be the case. My impression is that, and I'm fascinated by the way this regulation is attracting attention here. As I said, there is another framework that is being adopted, which is the directive on product liability, that people don't talk about here. Why? Because here, the AI companies are not that concerned about this product liability directive that has no extraterritorial scope. While the AI Act is attracting a lot of attention, and so my impression, and of course I'm not in the shoes of industry leaders, but my impression is that the industry is getting prepared to comply with these standards. And I really, and you know that, I really like this common law concept of persuasive authority. I'm not that sure that it's accurate to use it here, but it's not, even if those standards are not that mandatory at a worldwide scale, they exist, and so they are specified. So it's really important, I think.
Samit Chakrabarti.
Hello. Thanks for the presentation. Wonderful. So Europe has a very vibrant AI industry, and I'm curious what impact, if any, you think this act might have on the competitiveness of the European AI industry vis-a-vis the rest of the world. And how much do you think forecasts over what the impacts on competitiveness would be actually shaped the AI Act in the first place? For example, might it have had an influence on the big open source exemption?
Okay, good. It's a very good question. So yes, to start with the end of your question, it has been widely said in the EU that open source could be where Europeans could be competitive, that it could be their thing, that and that open source should be promoted as a way to be present on the market. So you would have, and it's really binary, and I apologize for this, but you would have, on the one hand, the US with proprietary models and the EU with open source models. I'm not sure that it's that true. A few days ago, and this has generated a debate in France, a very intense debate in France. But a few days ago, Mistral has announced a partnership with Microsoft, but also announced that their latest model is not open source. So we're not finished with this debate. So this is my answer about open source. And my second answer about your question on innovation in the EU. And I could say I have no final answer on this, because during the negotiations on the AI Act, still now, you have a debate about the compliance costs of those measures. And you know what, I am not in the right place to answer that question of compliance costs. Some people would say it's enormous, and some people would say it's acceptable. It's just the cost of doing business for companies. And I frankly do not know how expensive it will be to be, let's say, transparent, such as when you provide the technical documentation for other providers. So yes, this is what I would say about that.
I think that as the technology and industry evolve, and this is something that our colleagues over at OpenAI, at HAI are looking at. It's the long tail of smaller companies where we would wonder about both the competitive impact and the Googles and the OpenAIs and the Anthropics of the world. They're gonna maybe they'll gripe, but they'll be able to comply with this. But I think and you've heard me sing this tune before, which is that if we assume that this technology looks like social media or search, we're making a big mistake, right? Because it is this kind of keystone technology that's going to have all of these incarnations, and that the AI Act is, in thinking about deployers as well as providers, is trying at least to think about all these many use cases down the line, but it's going to be everywhere, right? And the hard part, I think, is going to be figuring out what's not covered by this, because all of these technologies are going to be sort of infiltrating the daily life of folks, in Europe and elsewhere. Yeah. So I think we've run out of time. I want to thank Florence again for both the report and this talk. Thank you. Thank you again to Tamika Tillman and Alex Pocenti for joining us here today. We really appreciate that. And join us next week, where Andrew I got to get this name right. I don't know if you've got it up there. Do you have it? Andrew Przybelski is going. All right. Andrew will be joining us next week, talking about, I believe it's on social media and well-being, part of our sort of continuing look at that we started in the fall about social media in teens, social media and psychological well-being. So join us again next week. Thank you all for coming.